Yes, good afternoon. So, Mr. Cribb, you've been deserted.
Yes, I'm afraid so, my lord.
Mr. Sebastian.
May it please the court, I appear as advocate to the court pursuant to the order of Males LJ. The court has my written submissions which were filed yesterday. Those submissions were oriented towards identifying reasons.
You're going to have to speak up a bit, Mr. Sebastian. I'm sure that over there in St. Petersburg it's not going to be heard, and it's certainly not being heard
Here.
3 meters away here.
Sure. Those submissions were oriented towards identifying reasons not to grant the application. That was in light of paragraph 8 of the Order of Males LJ. There is a difference between an advocate to the court and a devil's advocate. I'm afraid I have strayed a little bit towards the devil's advocate end of the matter, with a view to giving the court sight of all of the possible countervailing considerations. But I will be correcting that balance today when I take a view on what is really material. So I hope that my written submissions will be understood in that spirit.
Yeah.
I plan to address 4 topics in the submissions today. The first is what I will call the risk point, and that is what Mr. Hausman said as well.
Just explain that, I'm sorry. It just doesn't seem intuitive to me. The risk of what?
This was understood to be the primary reason put forward by UniCredit in favor of its application.
Well, the UniCredit is at risk of confiscation of its assets, effectively.
But the key question is, what gives rise to that risk? What's the trigger? And the risk point, we all understand one thing, that if they didn't apply, there was a risk that its assets would be confiscated. But that's water under the bridge. They have applied. The risk point is really another one, which is what was triggering the liability of 250 million. Was there a risk that it would be triggered dependent on the ruling of this court?
But you know, I find this difficult because the subtext seems to me to be the part of the evidence that says there is a possibility that without notice the same penalty would be imposed if the court refused the relief as had been threatened if UniCredit failed to apply.
That's the point, yes.
Yeah, so wouldn't we be playing with fire if we said, okay, UniCredit has made the application, so it's okay? We might find it wasn't okay and it would all have been a waste of time.
I think that is correct, and ultimately my submission is that that point fades away.
Right, okay, so we wouldn't have to spend too much time on it then.
We won't spend too much time, but I want to explain
Okay.
why it's significant, because it does raise, unlike other matters, it does raise a policy question for this court.
It raises
a question of public policy.
public policy, yeah.
If that is the basis of an application, that does raise a policy issue, which I'll come on to.
Yes, because it could be said that the court is being threatened by
Yes.
the other court.
The court is being threatened by the other court. It also changes the nature of judicial decision making. The factors that an English court is now considering is what will happen to innocent third parties abroad, and it may incentivize that sort of conduct abroad. It may even encourage it. If that was really a concern in this case. I'm not going to spend too much time on it because I think it has faded away in light of the clarifications. But it is a matter of public policy, and that's why I address it first.
Okay, yeah, that's the first point.
The second point I want to address is what I'm going to call the coercion concern. And that's linked to the question sent by the court last night. It's also linked to the concern that about RCA's position as a party in contempt, which is effectively coercing UniCredit. And what are the implications of that?
Yeah.
The third heading would be the implications of finality in this case. So I will then apply, having cleared the ground, I'll just ask the question how the court should approach what's left.
Mm-hmm.
And then finally, I will have a few comments about the threshold question of whether you have the power and the New York Convention.
Yeah.
Ultimately, I am of the view that this is a simple application, and once you strip away the public policy concerns, it is quite easy to deal with. But let me start with this risk point, which was the one that gave me difficulty when I was looking at the materials.
Mm-hmm.
So perhaps the place to start is paragraph 29 of the skeleton argument of UniCredit, which is at the application bundle, tab 41, page 572. And just reading from that, it says, more fundamentally, if the court were to refuse to exercise its power under CPR 317 to revoke the order, that would leave UniCredit at risk of being held to be in breach of the Russian SI with potentially draconian financial consequences. And this was put as the most fundamental reason to grant the application. Now, Mr. Hausman took you to all of the material about why that risk may not be straightforward. So you saw the actual terms of paragraph 3 of the Russian order. You saw how it evolved, and the letter from LP, and we've got that factual picture. But it is worth turning up one document that Mr. Hausman didn't take you to, which was the witness statement in support of the application, which is actually the first document. And that is at the third tab of the same bundle, page 22.
This is Mr. Claypool.
Correct. Paragraph 33. So Mr. Claypool's evidence was that there was a risk. He said, finally, I should make it clear that UniCredit is not just ticking a box by making an application without regard for the outcome of the application. UniCredit wishes the application to be successful, including to avoid the risk that RCA or the Arbitrazh court considers that compliance with paragraph 3 of the Russian ASI requires not only an application under 317, which everyone can see, but an order granting such an application. So just to cut to the chase, this is unusual. This sort of order, if it was truly the case, that UniCredit would be held liable to the tune of $250 million based on entirely, regardless of the steps it took, based on the decisions of the English court, that would be a different scenario.
Do we know why they care? Why the Russian court cares, or RCA cares, bearing in mind that they have decided to ignore the orders this court makes?
That is a point that is raised in my written submissions. It remains unclear to me why it cares, and the submissions from RCA that we heard just before the lunch break did touch upon this, and there was a suggestion that a contractual agreement between these two parties, that they would not enforce the anti-suit injunction, which would be the straightforward way to deal with a private dispute without troubling the court, as I understood it, there were two concerns with that. One was there was a concern that that agreement may be vitiated by coercion.
Vitiated by?
Coercion.
Yes.
And then I think the second concern, if I understood the submissions correctly, this is not in the evidence anywhere, it's just what we heard before lunch, was that there would be some uncertainty. It would be far more certain if the order was removed. But it remains a mystery to me exactly why so much resource has been invested in this, because the evidence that we do have on this matter is that RCA does not have assets in England and Wales, and its officers do not travel to England and Wales, and its officers don't have plans to travel to England and Wales. So that it is a mystery, and that's all I can say about that.
Yeah.
But that's something maybe we can come back to when we get rid of all of the points and just look at the balance finality. But it is a mystery. Going back to, for whatever reason, this risk was identified on the papers, and this risk would be something unusual, and the English court would have to be attentive to it if it existed. If the point was that an injunction was, although formally directed towards UniCredit, it was dependent on the conduct of the English courts, penal consequences for UniCredit. That does involve an interference with English justice. And it also...
Sorry, what involves the interference?
A foreign court stating that it would fine third parties dependent entirely on what the court does, regardless of what the third parties have done. If it were true, that is something the English court would have to be careful about if its processes were being used to vindicate that kind of interest and remove that kind of risk.
Well, I find that language very difficult, Mr. Sebastian. What does it mean to be careful?
It would have to consider it as a countervailing interest against granting the injunction.
Against granting, setting aside the injunction.
Yeah, against setting aside the injunction, against revocation. It would be a consideration of public policy that the English courts wouldn't want to set a precedent that they would be responsive to this sort of threat. Now,
But is there any precedent? I mean, this is really what I was asking you. Is there any precedent for the court saying, I am being threatened by a foreign court here? This is not RCA, this is a foreign court. And therefore, I will not respond to those threats.
None that I could see.
No precedent of any kind, anywhere.
For my searches.
Unbelievable.
Yes.
Right?
Well, it's based on the research I have been able to do, I have not been able to find that. I've not been able to find relevant precedent.
And I'm assuming nobody else in court has either.
Not as far as I'm aware, my lord.
That may be simply because it's very rare, and in this case it turns out it may not be what is happening.
But you say it's very rare, but my lord and I were exchanging anecdotes about our previous practices and antecedents, and actually it isn't that rare in anti-suit matters for courts to cross swords and to say no, and I'm thinking here of courts in other countries, not in Russia, but in America and other countries, where both courts have a long-arm jurisdiction, which they seek rigorously to defend. And, I mean, whether you reach a stage of threats in any way, we would obviously be reluctant to call it that, but whether you do or not, the situation must have arisen before.
Absolutely. What your lordship is describing is something that is completely typical, which is you have injunctions against two parties. They're directed to the private party, and they ask the private party to get rid of an anti-suit. There is a big difference between that and an injunction which, although directed formally to the party, is saying the penal consequences of this injunction depend entirely on what the foreign court does. They don't depend on what the private party does. For many years, the answer to committee concerns around anti-suit injunctions has always been the injunction is directed at a private party. It is not directed at a foreign court. And that is formally true in this case.
But it may be a distinction without a difference.
It may be a distinction without a difference, but there is a difference. In the ordinary case, all you look at is the private party's conduct. What have they done? Have they done their best? Then they're in compliance. This case seemed radically different because if the risk being described in Claypool 6 is correct, it doesn't matter that UniCredit did everything it could. Ultimately, what matters is what this court did.
This is where slightly. This seems to be a bit of a self-generated issue in a way here, because we know what the Russian court ordered.
Yes.
And that's the only direct evidence we've got of what the Russian court has done. But the reason why I think UniCredit is going further is because it's concerned that this court might say, well, you've done your bit. We don't have to do anything because you've made your application.
Yes.
And the only reason that what they're saying, as I understand it, is, well, look, we have to make this application, but by the way, there's always a risk that we will be held in contempt if the order isn't discharged. And there must be such a risk. For example, the foreign court might take the view that you haven't done your best, or you didn't make the right submissions, or you in some way subliminally indicated to the court that the court didn't actually have to. For instance, by saying to the court, all we have to do is make the application. That in itself might be regarded by the foreign court as a nod and a wink to the recipient court that they don't need to make the order. So I think that I don't think we need really get into the whole question about whether the foreign court is making an order that requires us to do anything, because they plainly haven't done that.
I agree with everything your lordship has said. Ultimately, we have clarification from RCA that that's not how they read the order of the foreign court. We understand from UniCredit that that's not how they read the order. It's not directed in terms such that it will be contingent on the conduct of the outcomes in the English courts. But it is also correct that there is a risk, some sort of risk, a marginal risk, and that may be sufficient for present purposes to implicate the jurisdiction to revoke. But the point is, yes, ultimately I agree on the facts. The point is probably not live, but it is something that the courts, if it were really the case that this sort of injunction or this sort of penalty is the basis for a revocation, then that is something that the English courts would have to be careful about. That doesn't seem to be the case we're in. That's all I have to say on that first point.
It seems a very fine distinction to me. I mean, you're saying only if the court in Russia had said, if the English court does not revoke its jurisdiction, we will fine its order, we will fine UniCredit, that we would then have to be careful.
You would certainly have to be careful in that situation. Yes. whether I'm saying
I hate this "be careful" because I don't know what "be careful" means.
Well, it's a countervailing consideration not to give in to that kind of order. It's a countervailing consideration when considering the balance, whether to displace finality.
Okay. All right. Well, I can understand why you might not want to say any more, but I find it a tiny bit unsatisfactory. Okay. Yeah, that's the risk point. So you think the risk point doesn't add up to a row of beans?
Not much.
Not many beans.
Yes. The second point is the coercion and RCA influence point. If I can take us to what I think really is the central justification for the order in this case, which I think of as now the party control point, that the party who had the benefit of the order is before you, and in a system of civil litigation, who should have control of outcomes, wants to revoke the order. And we see that seems to be a strong consideration in favor of revoking it. Again, we see this, if we can turn up their skeleton, it's tab 41, page 572. Paragraphs 28.
I'm sorry, 28 of what?
The skeleton argument, page 572.
UniCredit.
Yes, UniCredit skeleton argument.
Yeah.
And this point is the simple point that the successful claimant now seeks to set aside the final order it's obtained. And similarly, because of that, all parties agree that revocation would be appropriate. Now that strikes me as a strong reason for revocation in a system of private law. The only possible concern here is with how UniCredit got to this situation, and that's the coercion point, as the court raised it, and various phrases were used this morning: the compromise, choice, duress, or the lack of volition. The second related point is that the real driver of this application and this choice is RCA, who's a party in contempt. Taken together, that might suggest that the English court may not want to accede to the application because it's helping the interests of someone in contempt, or the party before it has been coerced to come before it. That's the shape of the argument as I see it. Mr. Hausman asked the court to focus on just the fact the consent had been given, and not to go behind that and ask why consent had been given and how it arose. In this case, the material we have about any sort of coercion on UniCredit and whether it breaches a threshold that would raise concerns for the English court when exercising its discretion, it appears that we don't have material to that effect. At the end of the day, RCA has utilized a Russian law remedy, which was granted to it. The penalties may be, to our eyes, eye-watering, but they were provided under foreign law, and the sums in dispute are large. And it is difficult to imagine what standard the English courts would apply to test that coercion, to test why UniCredit is before it, and therefore to treat it as a countervailing
But
consideration.
has there ever been a case where duress or coercion has been said to vitiate an application to the court. And let me just give you the answer to my own question. There is a family case which we have found, the name of which currently escapes me, but I'll get it. FAAF against AVA, which does appear to have been in that position. Let me just see if I can find it. Anyway, there was a family case where the application, the wife who made an application to the court was held to have been coerced into doing so, and the application was thereby declined. I think I'm right. We'll let you have this. But that is the only case we've been able to find, and the judge there said that all the commercial cases were irrelevant to what he had to decide, and it was the special family situation. But there's been no commercial case where it's been held that an application to the court made by a bank, a German bank, or even an Italian bank of a huge bank, was coerced and therefore could not be contemplated?
Not to my knowledge.
No.
Certainly, I made attempts to search yesterday.
Well, it would be a funny thing to do, because coercion is really the name of the anti-suit game, isn't it?
Absolutely. It is.
I mean, as my lord put it this morning, anti-suit injunction is a coercive order.
Every court order has the potential to be coercive.
Well,
every court order.
It is coercive, really.
Yes.
I mean, when we talk about the reason you can't grant injunctions against states is because they're coercive orders. You don't coerce a foreign friendly state or even a foreign unfriendly state. You just don't do it, generally.
Yes.
But in determining whether there were coercion, you might also be going into the commercial reasons for an agreement or a step being taken by a commercial entity, and that's something the court wouldn't and ought not to do.
Wouldn't ordinarily do. Yes. If I can just.
So you say there's no reason to take the coercion, the supposed coercion, into account as a countervailing feature
in this case, based on the material we have. Now, if I'm going to hand up something which is not directly relevant, but I just wanted the court to see it, which is the way this issue is better managed is through legislative policy. And
Have you got this electronically?
I do. I haven't sent it yet.
You don't? Okay. Could you send it? I don't really do paper. Yeah, I can't even read it because it's too small.
Apologies.
This is the council regulation imposing the sanctions.
Yes, it's a very recent council regulation. I'll just mention its content.
Is it the relevant one to this case?
No. It is an example. It's a recent. Sorry, I should.
I've taken a copy of it.
You've got. Yeah.
Helps myself, I'm afraid.
What about Mr. Sondor? How's he going to see this? He's going to search for it online. It's Council Regulation 2024/3192.
This is a council regulation.
Sorry?
He said thank you.
Oh, thank you. Okay. Yep, good.
Thanks. Oh, and apologies that this was not handed in electronically. I don't want to take much time on it, but this is a council regulation that is imposing sanctions precisely because of the type of remedy we've seen in this case. And it is a sanction that prevents entities from recognizing, giving effect, or enforcing in a member state any injunction, order, relief, judgment, or other court decision.
Sorry, where is that in this document?
Page 3 of 27. Article 11C.
Article 11C.
C. Page 3.
No injunction, that it?
Yes, no injunction, relief, judgment, or other court decision pursuant to or derived from Article 348 of the Arbitration Procedure Code of the Russian Federation or equivalent Russian legislation shall be recognized, given effect, or enforced in a member state. And if I can take the court very briefly back to recital 8, which is on page 2.
Is this binding in?
No, it is not binding. It is just an example of how the coercion concern is probably more appropriately dealt with, which is simply by legislative means. It's the legislature that has a better handle on this sort of conduct and how to respond.
I mean, I was immediately asking myself the question, is this a case in which we would be recognizing, giving effect, or enforcing?
And my views were not. The English court would not be. This is not a normal private international solution situation. You are not being asked to apply this law.
No, that's not the point I'm making. If we were still in the EU and this were binding on us, would we be, by withdrawing, varying the court's order, be giving effect to an injunction of the foreign court, of the Russian court?
That's possible. Yes.
We would, I think.
Yes. Because it says enforce, recognize, or give effect to.
Yeah.
But that isn't the law in this jurisdiction. And you can see that the Union considers that the manner in which, in that recital, in which Russian courts issue such anti-suit injunctions and fines is in clear violation of established international principles and long-standing practices in the resolution of international business disputes. That's the sort of inquiry that one would have to go into, and that's not something that's suitable.
And there's no legislation, comparable legislation here.
Not that I'm aware of.
Okay.
So the coercion point involves a complex inquiry which is just not suitable for this court and has never really been done in this commercial context. The remaining point is, what about the fact that the real agent, arguably the agent behind this, is RCA, and RCA is an entity in contempt. And this is the question that was raised yesterday. Now, I think the short answer to that is, although a party in contempt, ordinarily their applications will not be heard by the English courts until they purge the contempt. And that's for good reasons of ensuring compliance with English court orders. It's not RCA that is before the court. And that rule does not.
Well, it is before the court, but it's not making the application.
It's not RCA. So, I beg your pardon. I should correct myself. It's not RCA that is making the application. And those precedents do not apply.
Right.
So coercion and the risk point don't really add up to much.
So risk, coercion, contempt don't add up.
Don't add up to much.
Right. Thirdly.
So that leaves more abstract concerns about the interest in finality and how the court should treat that in this case.
There doesn't seem to be any dispute, does there, that a material change of circumstances will be sufficient?
There is actually a dispute on the No, I think there is a question about that, because if one looks at the Raut case, it says that a material change of circumstances would not be relevant when trying to set aside a final order.
But, I mean, that's, without being silly about it, Mr. Sebastian, if the parties agree in an anti-suit context that they no longer want an anti-suit injunction, just because they had a trial notionally, which really was only a notional trial, what they were really deciding was RCA's application to set aside on grounds of jurisdiction. But just because they had a trial, why should that make a difference?
This is the point. I think a similar point was made by Mr. Hausman. How is this so different from the other cases which allow for a discontinuance as a matter of substance? And I think the answer to that is that for finality purposes, you have to draw a line somewhere. And where the English court draws that line is when a final order has been sealed. And in substance, there is no difference between the cases where they've been able to put forward a discontinuance and this case. But English law draws a line when an order is sealed. It has to draw a line somewhere. That's where it draws it, and we're on the wrong side of that line.
Yeah,
So that brings us really to my third area, which is in light of finality, which is a presumption, and I have cited in my skeleton argument, I don't propose to take you to it, the Supreme Court case, the Nigerian airport case, and that tells you about the dead weight of the finality principle, and it tells you that of the structure of the analysis, which is to first examine the reasons given for displacing it, to then examine any countervailing reasons, and it is very clear that a final order has an extremely high level of protection under that principle. But that's just a structure for decision making. It's not really going to do much in terms of getting us over in this case. In this case, once one sweeps away the concern about interference with English justice, and once it's accepted that they aren't really manageable standards to assess coercion, there's no law, relevant law on that, you are left with a situation where, as Mr. Hausman said, the finality principle has two dimensions. The one dimension is protecting the parties themselves from being disturbed again, and that is not what we have here. And the second dimension is protecting public resources, court resources, and it's not just the court resources that went into the original judgment being wasted or thrown away. And that really hasn't happened. It is the court resources that are wasted today in having to consider these sorts of applications. And it is that public interest which strikes me, at least, as a not very heavy one, as a light one, when set against the potential prejudice to UniCredit and UniCredit's acute interest in a private law context. There are two cases that Mr. Hausman took you to, Madison and Cabot. For the second one, Mr. Hausman pointed out that there's a regulator in there, the FCA. The first one is also one involving a regulator. And I only mention that because this sort of case, what we have here is unusual. If you have a mandatory continuing injunction and both of the parties agree that they need to get rid of it or they don't need to have it, there's no need to disturb the court. They can just do it by agreement. Something unusual has to happen. In Cabot and Madison, it seems that the unusual factor is that the FCA wanted these judgments removed. It's hard to tell why. Both judges say they haven't got much transparency, but it may be something to do with the credit rating of the consumers. I'm just speculating. Similarly, in this case, it's very hard to understand why we're before this court, given that both parties agree that they don't want to enforce this injunction. But there is something inexplicable going on. For whatever reason, RCA, and it's managed to convince the Russian courts, wants this removed. And that does have acute individual prejudice to UniCredit. And I can see the strength of that position. And what would have to countervail against it would be some English public policy interest. And we've discussed...
We would have to be, it seems to me anyway, if the English court thought it was being blackmailed or threatened by a party. I mean, I suppose, or by a foreign court, but we've already dismissed that under the risks section.
Precisely. So if there isn't a public policy problem, the resources are not huge. It is private law litigation, which in our system at least is an entirely party-controlled affair.
Mm.
And one can see the strength of the case, although I confess I didn't immediately see it.
What do you say about the maybe obiter but powerful dictum from Lord Justice Lewison, with which Lady Justice Asplin, I think, may have agreed. But
Where is that?
Vodafone.
Vodafone, that there's an exception contemplated in the case of continuing orders such as the final injunction.
Like Mr. Hausman and Mr. Cribb, I couldn't find any authority for that.
But this is authority in itself.
Yes, but it says it's contemplated previously, and I couldn't find any prior authority that it was referring to. And it was a little difficult to understand. Ordinarily, you wouldn't get a continuing final injunction if it involved constant supervision by the court, if it was the kind of thing where someone would want to revise it. That would be a reason against giving it. So I found it a little difficult to understand.
Forgive me, I'm not sure about that, because there are numerous situations, for instance, injunctions against trespass, or any injunction to do with land that requires somebody not to do something to land is continuing.
Yes.
And one can think of, in those situations, that at some point it might be necessary to revoke that. Either because, and the thing about a final order is it will last forever.
It will last forever. I think I asked myself what sort of why is it that in those situations one considers that there will be reasons to revoke it, that will arise more frequently. At the time of granting the injunction, there will be a proprietary right, and it will have to be very clear that
Well, isn't it simply that where you have an order which has continuing effect, one can more readily see that a change of circumstances might make it necessary to revoke or vary it, isn't it? It's no more than that.
yes, that I can, and that is said by.
And that seems to me applies with particular force to this type of injunction, which is in quite a dynamic situation where there are multiplicity of proceedings around the world, and other jurisdictions may respond to what happens in this jurisdiction, and you might call your injunction final, but it is actually being granted in the context of other proceedings in order to protect them. So I have to say, I find the idea of a fixed final anti-suit injunction in this sort of context rather troubling. It must be possible to come back and say, well, actually things have now changed and we no longer want, no longer need, it's now inappropriate to have the English court restraining a foreign party from suing in a foreign jurisdiction. I thought that would be one of the easiest things to vary or revoke, where there is an appropriate change of circumstances. Do you disagree with that?
I think you can have two types of final orders. You can have damages, or you can have an injunction. One can't imagine it's much harder to imagine the former giving rise.
Well, you might have an injunction requiring somebody to deliver something up,
Yes.
or not to attend a meeting, or to vote in a particular way, which will be over. So there are many peremptory injunctions which will have a limited lifespan. But this kind of thing will go on forever. It will literally go on into the next millennium if you don't revoke it.
I have no real basis to disagree with that. So I suppose I should just explain what I said. I couldn't find a precedent where that had happened and where it was acknowledged prior to this case that was an exception. It's too obvious to have a precedent, possibly.
No, but is it common for final anti-suit injunctions to be granted, or are they normally granted on an interlocutory basis?
I might be able to assist with that, my lord. It is very typical that the pattern that you get with an anti-suit injunction is the interim anti-suit injunction is prohibitory only. So it restrains the continuation of the foreign proceedings. It restrains the commencement of other proceedings inconsistent with the arbitration agreement or jurisdiction clause. A mandatory injunction is often seen as something that can only be granted by way of final relief. Mandatory injunctions such as the one granted by the Court of Appeal in this case, requiring RCA to withdraw the Russian proceedings, because relief of that character can be final, where, as I understand is the position in Russian law, and that was the evidence in this case, withdrawal is with prejudice. So if the Russian proceedings had been withdrawn in compliance with a mandatory injunction, they couldn't then have been recommenced. So there are certain forms of anti-suit injunctive relief which it is seen as inappropriate to grant by way of interim relief because they're irreversible. And so to that extent, there needs to be an inter partes hearing in the form often of a partate trial, which doesn't look that different in practice to a return date on the injunction.
Well, that's the
to
problem,
determine
because
the issue.
Very often the parties don't distinguish, and one of the problems which certainly I saw was that the parties would, because the only relief being sought is an anti-suit injunction, parties would come back on the return date, and an injunction would be made on the return date, but then nothing else would happen, because nobody saw any need for anything else to happen. So that would remain, theoretically, an interim injunction, because nobody would come back to have the trial of the partate claim. But there should be, in theory, you should, at the end of the day, have a determination of the proceedings.
It depends slightly on what the nature of the defence to the claim, to the anti-suit injunction is. If there is a substantial dispute about the arbitrability of the issue taken to the foreign proceedings, the construction of the arbitration or exclusive jurisdiction clause, it may then be that there needs to be a three-stage process rather than the two-stage process that we had in these proceedings. So a without notice interim injunction ordering restraints, a return date where it is considered inter partes, whether it is appropriate for those prohibitory restraints to continue to trial, and then a further trial determining that substantive question as to whether final relief, including potentially mandatory and irreversible relief, is appropriate. The reason the timeline was compressed in these proceedings was one, in light of the evidence that was then before the court, of the risks of the Russian court dealing with matters itself on an expedited time frame, and also I think it would be fair to say there wasn't any substantial issue for the Part 8 trial that wouldn't be duplicative of a return date. So my lords and my lady might have seen in the Court of Appeal judgment that both before the Court of Appeal and before Sir Nigel Tier at first instance, the jurisdictional questions in terms of governing law and the like were dealt with just in terms of who was right about that, rather than as to who had a good arguable case. So effectively in this case it was the return date that dropped out, not the final hearing. I hope that assists in clarifying how that might have happened in this case.
Yeah, thank you.
In terms of the structure of the discretion and the countervailing factors, I only have two more points.
Yes.
To make by way of wrap up.
Mm-hmm.
The first point is something we've touched upon already, which is it's not clear what the real benefit to RCA is from revocation, but ultimately I can see the strength of the point that doesn't matter in a situation where UniCredit is subject to risk. So although it's a mystery why we are before the English courts, it would be a strong thing to place a huge risk on a risk on UniCredit simply because we don't understand. It's mysterious why we're all here. So I can understand that in the balance. And finally, the New York Convention point. It is difficult to imagine that would change anything.
If the parties agree.
Yes. So the considerations or a lot of the concerns raised in my written submissions faded overnight, or at least I've understood things better a day later. It's one of the two. The only remaining point I wish to make is
That's the second only remaining point.
no. Sorry. Yes. No, those were the 2 points. The New York Convention. This is my last heading, which is about power.
Power.
Yes.
Mm-hmm.
And on that, my skeleton went, I think, certainly, my written submission certainly went too far on the Court of Appeal point. So I think the questions before the court are this CPR 52 point. There is a good answer to that, at least from where I sit. The technical point that I have raised about CPR 317 being about powers under the CPR and not powers under the senior courts. Again, I think that's obviously a purely technical point, and there was an answer to it from Mr. Houseman. The answer is that every order is under the CPR. That is an answer. Those two questions would have to be are the first two that have come up, and then the remaining question is one that is well worn, and that is the question that we went to all of the Court of Appeal cases on 317, and I can see the sense in having some sort of residual jurisdiction, and it may be too late to shut that because the Court of Appeal itself has given relief in respect of final orders, possession orders, etc. So it is no matter what the position might be, as a matter of principle, I think this court has that power. Unless that concludes my submissions, unless there is something I can help the court with.
No, thank you very much indeed, Mr. Sebastian. We appreciate your help, and we particularly appreciate your help at such short notice. Thank you. Mr. Cribb.
I'm grateful, my lords, my lady. I'm going to endeavour to be as brief as possible and not to repeat anything my learned friend Mr. Houseman said. I'm going to deal with 4 points in the order that my learned friend Mr. Sebastian dealt with them. Risk of prejudice, the relevance...
You actually agree with Mr. Sebastian on all those 4 points, don't you?
Largely. There are certain points of detail where I wasn't entirely sure of quite where the landing was, so I thought it might help to clarify precisely how we see things on behalf of UniCredit. My lord has alighted on a sort of general point that I was going to sort of advance at the beginning, which is I'm not sure at the end of what my learned friend was saying that he in fact says that the application should be refused. Now that's not a criticism because he's not here in a capacity as an opponent.
It's not up to him to say that.
But it nonetheless felt worthwhile on my part to draw that out as a point of emphasis before I get into the detail. Risk of prejudice. The party which ultimately, or entity or body, I can put it that way, which ultimately determines compliance with the Russian court's anti-suit injunction is, unsurprisingly, the Russian court. And in my submission, this court should not be exercising its discretion on the assumption that my client is exposed to no meaningful or real risk in Russia, as aspects of my learned friend's skeleton previously suggested. Because if that skeleton were wrong in its prognosis, it would be my client that would be left exposed to the risk of substantial prejudice as a result. And that would, in my submission, amount to playing with fire, as my lord the Master of the Rolls suggested, because one might see that the Russian court could think that, in fact, revocation of this injunction should be straightforward, where the parties agree to it. And if it were not to be revoked, it might draw the inference that the reason for that might be because UniCredit did not try hard enough.
Well, I think that's all the points that my lord made in
exactly.
Mr. Sebastian without him pushing back.
I endorse those. What I wanted to show the court was just an aspect of the Russian law evidence that was put before the Russian court when it made the order. This is at tab 33 of the bundle. This is an opinion of English law submitted by RCA to the Russian court in support of its application, and it therefore stands to reason that this formed some of the basis for the Russian court making the order that it did. And what I draw my lord's and my lady's attention to is paragraph 3 spot 12 on page 263, where the Russian court has been told that if RusChem and Commerzbank, pausing here, this was first filed in RCA's litigation against Commerzbank and then refiled in its litigation with UniCredit. If RusChem and Commerzbank both agree that the English anti-suit injunction should be revoked, then in my view the court is likely to treat this as a highly relevant factor in exercising the discretion. So the English court could well see how the Russian court, in light of that evidence, might be of the view that the application now before this court is a straightforward one, and take it that something has gone amiss if it nonetheless is refused. So there are risks which my client UniCredit can't exclude in how the Russian court deals with this. A Russian court order of the form UniCredit has breached the injunction, not because it can't control what the English court does, but because actually, in fact, the Russian court in this hypothetical scenario has concluded that UniCredit didn't do enough, wouldn't be an order punishing the English court for its decision. It would be an order punishing UniCredit for not working hard enough to get the order it was injuncted to try to get. So that's risk. Coercion. I think I ultimately agree with where my lords and my lady and my learned friend came out on this.
We haven't come out anyway.
Or rather,
just for the
not
avoidance of
come
doubt.
out. I put that too high, my lord. I apologise. Certainly, I'd associate myself with the conclusions that my learned friend made, which is that coercion isn't a meaningful factor in the analysis here. I can see how it could be said to be a meaningful factor in the analysis if the court were to conclude that the vitiation of intent or volition were so extreme that the application could be said not in fact to have been made by UniCredit and were to be regarded as a nullity. There's no authority that any of us have been, or any of counsel have been able to find to support the proposition that the court could reach that conclusion or should reach that conclusion in respect of a commercial party. In fact, if anything, a refusal of the application by this court on the basis that UniCredit's application were deemed to have been a nullity would itself expose UniCredit to risks in Russia. If the application is deemed here not to have been made by UniCredit, what does the Russian court make of that? I don't know. But that in itself, in my submission, means that this would be a very dangerous line of reasoning with which to travel. On the point about hearing contemnors, my client isn't a contemnor. My client is the unfortunate victim of the circumstances in Russia. But my learned friend, Mr. Houseman, did refer before the lunch adjournment to the case of Him Pro, which I understand has been emailed to the court. I don't want to spend time on it, but just a snapshot of what that case was about. It was actually the sort of jurisdictional anti-suit bust-up that we've been debating before the court today. A Hong Kong-based freight forwarder commenced proceedings, a number of proceedings in China, bringing claims in respect of bills of lading. The counterparty to those contracts brought a claim for an anti-suit injunction in England, alleging that those Chinese proceedings had been commenced in breach of an exclusive jurisdiction clause in England. Those anti-suit injunctions were roundly ignored by the Hong Kong party, and the Hong Kong party itself and its director were in fact held to be in contempt. The trial happened, a final injunction was made, and then the Hong Kong party sought to appeal against the conclusion that the jurisdiction clause relied on was in fact exclusive. And so the Court of Appeal was faced with this difficulty where the appellant had multiple unpurged contempts of court. That's at paragraphs 24 and 25 of the judgment. It nonetheless raised an appeal, and the court had to decide whether it could hear the appeal or not. Paragraph 26, the court holds that it has a discretion whether or not to hear the appeal, notwithstanding the contempt of the appellant. Paragraphs 30 through 32, it decides that it will hear the appeal. It ultimately dismisses the appeal on the merits. But if it can be right in the context of that sort of jurisdictional bust-up to hear the appellant in that case on its appeal, notwithstanding that it had been found in contempt and which it had never purged, a fortiori, there can be no bar on hearing the application of UniCredit, which isn't a contempt law on any view.
Okay.
So that's coercion. The third point was finality. We don't dispute the generality that finality is an important aspect of English public policy. We just say that its impact in the exceptional circumstances of this case is attenuated. First, because it is the party with the benefit of the order which seeks to have it revoked. But also the second point, and this is where I will elaborate a little bit on what my learned friend Mr. Houseman said earlier, in terms of the expenditure of curial resources, it's important to bear in mind that the argument in this court and in the Supreme Court was almost exclusively jurisdictional. The written submissions, the oral submissions, they were all directed to the question of whether the court had jurisdiction to deal with the claim. And the judgments of this court and the Supreme Court stand as precedent on the determination of those issues and clarify English law accordingly. The bit of the relief sought to be varied by this application was the grant of the final injunction. That was a consequential matter that received very little appellate time in this jurisdiction. It was addressed very briefly in my skeleton on behalf of UniCredit. It wasn't substantially addressed in RCA's skeleton. The oral argument was directed almost exclusively to the jurisdictional issues, and the relief was then addressed in 4 or 5 paragraphs at the end of Lord Justice Mayall's.
But the waste of curial time isn't the Court of Appeal hearing and the Supreme Court hearing. The waste, if anything, will be this hearing. So I'm not sure why it helps us to examine what happened before.
I suppose where I push back on my Lord's question there is where my client did not foresee the material change of circumstances which has necessitated this application, and where it is not the author of its own misfortune.
Well, your point is that there's no... Your point surely is that in the ordinary run of things, this was a consent order which was made on the papers, and it's only because the matter has been ordered into open court for a public hearing that there is any... So there's nothing inherent in this process which is a particular waste of court time. It's parties have agreed this order be discharged, and in most situations that would be relatively straightforward.
It is certainly true that that is the basis on which the application
That must have happened many times.
is made.
It must have happened many times when parties have been ordered to discontinue English proceedings. Just that it just has never come... I mean, it just so happens in this case that the final order was made by the Court of Appeal after a trip to the Supreme Court. So it's attracted rather more focus, perhaps, than what I must assume will have been at least a number of other applications where it wasn't so controversial. Sure, it's a point in your favour.
I think I would have to accept that the applications made by other banks in a similar position at first instance to revoke final orders also sought determination on the papers, and that Mr. Justice Henshaw considered that the determination of those applications, or at least of Commerce Bank's application, would have required a hearing, and he listed a hearing for last Friday, albeit that was adjourned behind this hearing. So that there is that factual point.
When's it adjourned to?
I don't believe a further hearing, I'm not aware of a further hearing having yet been fixed. it may be that in light of this court's decision, the commercial court then feels that it can deal with those applications on the paper as the applicants had originally sought.
Yeah. Okay.
But I think my lord is right that the time today is probably more material. I'm just reluctant to characterise it as a waste, where this is an important case, an important.
I think, I think you're tilting at a non-existent windmill.
Well, if the windmill doesn't exist, I'll cease to tilt at it, my lord. I'll move on to my next point, which is power. All of which is to say that there's no limit in the language of CPR 3.17, which precludes its exercise in relation to a final order. There's no authority binding on this court, which precludes its exercise in relation to a final order. It's not a Taylor and Lawrence case. On the technical point, we've had an answer to that. We've got an answer to that. Even if there were force in the technical point, it must be implicit in Section 37, or the inherent jurisdiction of the court, that there is at least the power to vary a continuing injunction that the court has previously ordered. Because if you can't exercise 3.17 in respect of an injunction, because the injunction is made under Section 37, then an injunction could never be varied, and that can't be right.
I think that might be another windmill.
I'm answering the points that seem to me to be left, but I hear what my lord says. So at the end of the day, this is really about the exercise of discretion. And in view of the real risk of prejudice to my client, which was not foreseen and was not of its making, I would respectfully invite the court to grant the application. If there can be of any further assistance.
Thank you very much. Yeah. Is there anything, Mr. Sondor, that you feel moved to say? You don't really have a right to say anything further.
Pardon me, Your Lordship, I didn't get that.
He didn't hear you.
Pardon me, Your Lordship, yeah, I didn't get what you just said.
Sorry, I said, did you want to say anything more? You don't really have a right to say anything more, but if you had anything important you thought we should know, I would hear it.
I mean, nothing substantial, Your Lordship, apart from further clarification that RCA's intent for this order to be removed is not mysterious. But if that is of no interest to Your Lordship, then I would keep silent on that.
He said RCA's intention is not mysterious.
Oh, not mysterious.
And
No.
that he won't say anymore unless you want him to.
Okay, I mean, in one sentence, why is it not mysterious?
It is not mysterious because any commercial entity would not want a judgment against it in any jurisdiction, especially if no one any longer wishes to have all the disputes in Paris. So the coercive judgment to have all the disputes in Paris should fall away. That's no mystery. Thank you.
So what you're saying is that any commercial organization in the world would not want a judgment against it that it was not complying with if it could avoid it.
Yes, my lord, certainly. And very last point, if I may, and thinking out loud, would the analysis change if that was a part of the settlement agreement between our client and UniCredit, that UniCredit drops its order in England and RCA drops subsequently its order in Russia? And would that make any difference in terms of if there is any loophole for that, and and then why. That'll be the end.
Yes. Okay. Well, thank you very much for that, and thank you, Mr. Sondor, for your courtesy in attending these proceedings and in making your submissions to the court. We much appreciate that, and we hope you've been able to hear and see clearly enough. We are going to take... That's a pleasure. We are going to take time to consider our judgments. I would be reasonably optimistic, but without making any promises, that you will receive the judgment next week at some stage. I'm not promising, but I hope so. I do not take from the submissions we heard this morning that there is such urgency that we need to rush rather than reach the considered decision that is necessary in a case of this importance. So we will take our time. You will get the judgments in the normal way. When you do, please make sure you do not use the judgment for any purpose except agreeing an order and the disposition of costs until the hand down. It is likely that the period between draft judgment and hand down will be very short indeed, so you better make preparations for getting your responses to us in that period. We will, if needs be, give you longer to agree an order and disposition than the period between draft judgment and hand down, which may be only a matter of hours. Very good. Well, thank you all very much, and that concludes the proceedings.
Court is available.